Welcome from the heart of Munich at Café Datenschutz. Today we will be discussing the use of AI in companies, as well as the data protection legal framework that governs it. What companies should consider, that in today's video. Currently, many data protection authorities are dealing with the topic of AI, especially due to the emergence of ChatGPT. Firstly, the identical data protection framework conditions are applicable in this case, just as we are accustomed to in the company when utilizing other software solutions. On the one hand, it must be documented in the directory of processing activities. Then, if a third-party service provider is involved, a data protection agreement must be concluded with them, and the data subjects must be transparently informed about the data processing operations. Looking beyond, let's focus on a few special topics in the use of AI. And when I talk about AI here, I mean in the context of large language models, such as those used in ChatGPT, for example. To begin with, the training of large language models using proprietary material gives rise to data protection concerns and poses significant data protection issues. Secondly, there is a prohibition of automated individual decisions in the General Data Protection Regulation. In principle, it is imperative to avoid simply outsourcing a decision to a computer, especially when it has relevance for another person or individual. Specifics can be located here displayed and also linked below. Therefore, it is not easily feasible to allow the AI simply determine things that are pertinent to another individual in a straightforward manner. The third subject matter is the emerging regulation at the European level in the context of the AI regulation framework established by the European Union. Whether and in what form it will come is currently the subject of political discussion, but it is definitely relevant for companies to observe this when AI is to be used. Let us examine three particular use cases where artificial intelligence is presently being utilized frequently in companies. On one hand, there is translation AI, which is a type of software that assists you in translating texts from one language to another. It is especially crucial to make sure that prior to sharing any trade secrets or personal data with this tool in any manner, you establish a data protection agreement with this company. These privacy agreements are frequently only accessible with the Pro or Business Edition from the typical providers, which are subsequently subject to payment. On the other hand, it means that a data protection compliant use in the payment variant is justifiably permissible with many of these tools. Second use case, image generation. Here, also, it is important to make sure that you do not upload your own image material, as long as it contains personal data, for training the image generation artificial intelligence. Where you can easily use these AI models for image generation is again when you have image material generated, for example, for illustrating your own texts or websites. And at this point, we come to the third use case, which involves the utilization of large language models such as ChatGPT. In the basic version, as you are presently able to access it through your browser or smartphone, the entered material is utilized to train the large language model behind it and can therefore theoretically be read out by other users who have permission to do so if they are authorized to access the content. That means no trade secrets or personal data should be entered here. ChatGPT OpenAI provides users with the ability to utilize its own large language model by means of an API accessed through an interface. For this interface, a data protection agreement is also provided. On the other hand, it is ensured that the material provided via the interface is not utilized to train the large language model. So here a possible use case is emerging. OpenAI has also announced that it will create a Pro Access option for the browser version and the smartphone version, which will be available for a fee and where the input data will not be used to train the large language models. To speak with Carl Valentin, hopefully it won't be as bad as it already is, and thus the conclusion about the use of AI in the company. To begin with, the management retains legal responsibility when employing external AI tools, meaning they are still accountable for any consequences that may arise. Secondly, as long as no personal data and/or trade secrets are shared with external AI tools, this is possible without any data protection issues. Also, basic data protection topics, data protection agreements, affected information, and internal documentation must be considered. When training large language models, caution should be exercised to ensure that, if they are external, the provided material is not utilized to train the large language models. And additionally, the ban on automated individual decision-making and potential regulation of AI at EU level must be considered in relation to data protection law. What else happened in data protection? The Federal Labor Court has ruled in a recent case that the position of chairman of the Works Council is generally not compatible with the appointment as data protection officer. Link to the press release of the court in the description. Have fun reading the picture.